Good. Take that up. No, I will.
All right, this is Nicholas James Gale. It's case number 26133708 FH. Mr. Gale is here for a pretrial conference. The court's been advised that he wishes to enter a plea. Is that correct, Mr. Greer?
It is, Your Honor.
Is that correct, Mr. Gale?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth? Is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Put your hand down. And Ms. Robinson, what's the agreement in this case?
Your Honor, the agreement on this case is that the defendant will plead to a retail fraud first degree, so count one with a habitual offender third offense notice, restitution on all charged conduct. People would offer a sentence within guidelines on the minimum. We preliminarily scored those guidelines at 12 to 36 months.
Concurrent with Mason. Concurrent with Mason.
Your Honor, again, we would be seeking nothing consecutive with Mason County. However, there was a thought that he might be on parole or something else, and obviously at that point, we wouldn't have any control over that.
In my sheet from the New England County Sheriff's Office said that there was a parole violation, at least for some period of time, and a detainer in the file. So, Mr. Gill, are you on parole now, sir?
Yes, Your Honor.
Okay. All right. So you understand that this has to be consecutive to your parole. Understand that?
Yes, Your Honor.
Concurrent, but I told him concurrent to the Ottawa or Mason?
Mason.
Mason County.
Which is 46 months.
Mhm. All right. Okay. All right. So, Mr. Greer, is that your understanding of the agreement?
It is.
Yours as well, Mr. Gale?
Yes, Your Honor.
Okay. So the charge that you're entering a guilty plea to reads as follows: that on or about October 30th, 2025, that you were in the city of Fremont, Wake County, state of Michigan, that you committed the crime of retail fraud in the first degree, that you were in a store or its immediate vicinity, which was Walmart, which was open to the public, alter, transfer, remove, and replace, conceal, or otherwise misrepresent the price at which property was offered for sale with the intent not to pay for the property or to pay less than the price at which the property was offered for sale, resulting in the difference of price being $1,000 or more. This is a felony which carries up to 5 years in prison and or $10,000 fine plus cost, or 3 times the value of the difference in property stolen or money obtained. Do you understand the charge and the maximum penalty?
Yes, Your Honor.
So they're dismissing count 2, which is also a retail fraud in the first degree. Do you understand that? We're dismissing count 2, which is another retail fraud first degree.
Yes, Your Honor.
Okay. Then you're pleading to be an habitual offender third. Do you understand that?
Yes, Your Honor.
Okay. What that means is you have at least 2 prior felony convictions. Do you understand that?
Yes, Your Honor.
What they've alleged here is that on or about November 8, 2010, you were convicted of home invasion second degree in the 51st Circuit Court for Oceana County. Do you have that prior felony conviction, sir?
Yes, Your Honor.
Okay. And May 22nd, 2017, another breaking and entering with intent in the 51st Circuit Court for Oceana County. Do you have that felony conviction as well?
Yes, Your Honor.
Okay. Therefore, you may be subject to enhanced penalties of up to 10 years and or the $20,000 fine plus cost. Do you understand how the habitual offender third could increase your maximum penalties?
Yes, Your Honor.
All right. Now, you have a sentencing agreement that you are to pay restitution on whatever happened in count 2, which was another retail fraud at Walmart. You understand that?
Yes, sir.
And restitution on this case. And that should be sentenced to a sentence within the advisory guidelines. Do you understand that?
Yes, sir.
Prosecution has provided an estimate of 12 to 36. Your guidelines, as I score them at the time of sentencing, could be higher than that, or they could be lower than that. Do you understand that?
Yes, Your Honor.
So, for example, in this case, if the prosecution properly scored the advisory guidelines, the least that you can expect would be 12 months in the county jail sentence. Or you could get up to 36 months with the Michigan Department of Corrections. Do you understand that?
Yes, Your Honor.
And your maximum penalty could be up to 10 years with this habitual offender third. Do you understand that?
Yes, Your Honor.
Is that your complete understanding of the plea agreement in this case?
Yes, Your Honor.
Have you had sufficient time to consult with Mr. Greer about these charges and this plea agreement?
Yes, Your Honor.
Subject to the plea agreement, how do you wish to plead?
Guilty, Your Honor.
You understand that if I accept your guilty plea, that you're giving up the right to have a trial of any kind. You understand that you're giving up the rights that you would have at that trial.
Yes, Your Honor.
We've listed those rights for you on a written advice and right sheet that you signed. It's dated February 21st.
Yes, Your Honor.
Did you read that document?
That's what you said.
All right, so you signed that yesterday?
Yes, Your Honor.
So the 22nd.
I think it was the 21st, actually.
Yeah, I think it was the 20, it was Saturday.
Saturday would be the 21st.
Yeah, it was the 21st. It says the 22nd. That's my.
So Mr. Greer came to see you at the jail on Saturday, and you read this document and you understood those rights, is that correct?
Yes, Your Honor.
You went over them with Mr. Greer.
Yes, Your Honor.
Has anyone threatened you to get you to make this plea?
No, Your Honor.
Has anyone promised you an outcome different than we put on the record?
No, Your Honor.
You're entering this plea of your own free will.
Yes, Your Honor.
You understand that if I accept a guilty plea, you're giving up the right to even claim that this plea was not your choice.
Yes, Your Honor.
You understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea.
Yes, Your Honor.
Now give up the right to a trial of any kind, now the rights you would have at that trial, and you affirm your guilty plea.
Yes, Your Honor.
So on or about October 30th, 2025, were you in the city of Fremont, Nuevo County, state of Michigan?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
Did you go there by yourself or with somebody?
Listen,
Okay, and who'd you go with?
Amanda Stephens,
Okay, and who is Ms. Steffes to you?
she's an ex.
Ex-
Girlfriend.
Ex-girlfriend, ex-wife?
Girlfriend.
Okay. And why did you guys go to Walmart that day?
Said why?
Why, yeah?
The initial intent was to get a gallon of milk. Just needed a few things that had to get for the weekend.
Okay. And then when you got there, did you end up stealing some property?
Yes, I did, Your Honor.
What'd you steal?
Various items, some earbuds, some pair of sunglasses, just quite a few items. Some art tools,
Some tools, you said?
like hand tools. I opened cereal boxes and I put the tools in the cereal boxes and I paid for the cereal boxes. Your Honor.
Okay. What else did you steal?
Yeah, some of these items. I think that's it.
Okay, we'll just.
So, camping light, fresh pet, dog toys, instant film, dog meds.
No, that's me.
This was in the car. That he
Okay.
said he put back in this report.
Okay, so he says that there was some stuff in the cart that he got caught that got returned, so he did not.
Some of the items on this.
Hang on, that goes to restitution, but you still.
Right,
Yeah.
So do you think the value of all that stuff that you took without paying for it had a value of at least $1,000?
What he's saying is that he didn't get out of the store with these items.
It doesn't matter.
Still over $1,000. But what was in the cart was 1,000 actually?
Yeah.
Whatever you hid or didn't pay for, that you passed the cash register with the intent to steal it, did it have more than $1,000?
He says it was under 1,000.
All right, then I'm not taking it.
Your Honor, yes, I would ask that this be set for trial.
Trying to upset anyone here.
All right,
Right, that's for restitution, that's not
we'll
attempted.
set this case for trial.
Okay. I'll come down, don't worry.
Set this case for trial. April, well, let's do it, May 19, 20, 21, and 22. And we'll have a final conference. Let's do it March 23rd at 2:10.
Your Honor.
I'll get you. Okay, all right.
The hearing in this case, involving Nicholas James Dale, shows how a plea deal can quickly collapse when a key legal element becomes disputed in court. Initially, the defendant appeared ready to plead guilty to first-degree retail fraud related to an incident at a Walmart store in Fremont, Michigan. The agreement included restitution and a potential sentencing guideline range of 12 to 36 months, with a possibility of enhanced penalties because of his prior felony convictions. However, the turning point came when the court questioned the value of the stolen merchandise. Under Michigan law, first-degree retail fraud requires that the value of the property involved be $1,000 or more. While the prosecution suggested that the items in the cart reached that threshold, the defendant stated that the value was under $1,000. That statement created a legal problem. If the value is indeed lower, the charge might not meet the requirements for first-degree retail fraud. Because of this disagreement about a critical fact, the judge could not accept the guilty plea under the proposed charge. The defense attorney then requested that the matter proceed to trial. As a result, the court scheduled future dates for a final conference and trial. This moment highlights how even a single factual dispute, especially about monetary value, can completely change the direction of a criminal case.